All right, guys, we have a massive Fifth Circuit Court of Appeals ruling in the pistol brace case, Mock v. Garland. This is the ones that are being headed up by our good friends at the Firearms Policy Coalition. Be sure to check them out. You've heard me talk about them before. Now more than ever, they, as well as our other fantastic groups out there like Gun Owners of America and so forth, need our support. Now, what we're going to be telling you is what you need to know, what the judges talked about, and what is happening next. One of the big things I want people to understand is that this was not handled under the Brune decision or the Heller decision. This was not really decided out of a specific lineage of Second Amendment law, which is probably striking you as a little bit of a surprise. We're going to get into that. This was not handled that way because the ATF's rules does not comply with the nation's historical tradition of regulating firearms. Again, nothing to do with the Brune decision. And in fact, if you search the 58-page case decision linked in the description box below, you'll see Brune mentioned only a few times. And again, at least right now, this was not ruled on because of the Second Amendment grounds. Here's what you need to remember to set up the case. Prior to the final rule that was issued on January 31st of 2023, there was a proposed final rule last year. This is important. Stay with me. The proposed final rule contained a worksheet called Worksheet 4999. Sounds a little dystopian because it is dystopian. Worksheet 4999 would score devices and guns to determine whether or not they had enough points to qualify or fail to qualify as being a short-barreled rifle or SBR. Therefore, of course, subject to NFA taxes, laws, generally making you a felon, sending you to prison, things like that. Details. The proposed rule with the worksheet at its center was slammed by more than 217,000 negative comments. Now, rather than proposing a new rule or modifying that existing proposal for the rule, the ATF just decided to basically plow ahead. To use the Frank Reynolds term, they came out blasting with the final rule on January 31st of 2023. That final rule no longer contained any worksheet or point system. Instead, and you're going to see how this all connects together, so stay with me. Instead, there was now a completely different and extraordinarily unclear 6-factor test that assessed the, quote, design features common to rifles, end quote. The same final rule simultaneously declares that the objective criteria given to assess certain factors, quote, are not themselves determinative, and that adjudications by the ATF are made on a case-by-case basis. I will note that every single one of the so-called case-by-case adjudications by the ATF, without exception or explanation, ruled that the pistol brace in question was indeed a short-barreled rifle. Owner without the paperwork, as we discussed before, that's up to 10 years in prison. In many states, there is zero way to lawfully own a short-barreled rifle whatsoever. In brief, the ATF just duped millions of Americans into purchasing devices that year one, they said these are perfectly okay around 2013, only a decade later to say, nope, too bad, so sad. Here's a quote from the case. Quote, plaintiffs are likely to succeed on the merits and have thus carried part of their burden to obtain a preliminary injunction. That's from today's case ruling in Mock v. Garland. The court went on. On that front, plaintiffs establish a substantial likelihood of success on the merits. The ATF incorrectly maintains that the final rule is merely interpretive, not legislative, I'll explain, and thus not subject to the logical outgrowth test. The final rule affects individual rights, speaks with the force of law, and significantly implicates private interests. Thus, it is a legislative in character. Then, because the final rule bears almost no resemblance in manner or kind to the proposed rule, the final rule fails the logical outgrowth test and violates the APA. You can find that on page 23, the linked description or case decision below. What the heck does that mean in English? All right, let's start breaking this down quickly. And this is going to be important because this is where your rights, this is where my rights, this is where all of our rights are getting fought and won and lost in the trenches of things that probably 6 months ago, 10 months ago, most people didn't know anything about. Administrative Procedures Act, the APA. Let's start off with talking about what is interpretive or legislative intent. And generally speaking, the APA is dealing with the rulemaking abilities and what are their boundaries for the 400 some odd administrative agencies and sub-agencies that are out there across the United States. Because remember, legislative bodies, they pass laws, but it's the interpretive bodies, it's the fourth estate, it's the bureaucracy that gets to often interpret those. But interpret does not mean legislate, and interpret does not mean that they can't go beyond the clean meaning, the clear meaning of what the statute says. They cannot contradict the statute. So at a certain point, they're now basically starting to legislate rather than to interpret. That's the gist of what we're getting at here. And that's the gist of what the trenches where these battles are being fought. What is an interpretive versus legislative rule? This is going to be really quick. A legislative rule has the effect of binding the public by force of law. An interpretive rule does not. The ATF is claiming that they are not changing the statutes on short-barreled rifles. They claim that, in my case as a Wisconsinite, that the short-barreled rifle statute was the same on January 30th before the rule went into effect. It was the same on January 31st when it was published. And it was the same on February 1st, the day after it was published. The ATF is basically saying in court, you know what? This isn't our problem, in essence. We didn't change any laws. We didn't change anything. This is not legislative intent. The court cries foul. The court points out from case law that two of the markets for legislative rules are that they are functionally affect individual rights and create a new law, as you heard me reference earlier. The court then launches into a discussion about 5 different factors to determine whether or not a rule is legislative versus interpretive, and they basically adopt a test and on and on and on. And I think pretty plainly, when you upstroke millions and millions of Americans by reclassifying them from perfectly legal to felons, that feels rather legislative to me, don't you think? Prison feels legislative to me. So I don't think we need to waste a lot of time dwelling on those inane arguments put forth by our government. But next, if it's legislative, okay, so what? What happens next? What rules of the APA did the ATF supposedly then violate or run afoul of? Well, because the final rule is properly characterized, now a lot of this is what the court said. Because the final rule is properly characterized as a legislative rule, it must follow the APA's procedural requirements for notice and comment, including providing the public with a meaningful opportunity to comment on the proposed rule. The final rule the agency adopts must be a logical outgrowth of the rule proposed. So if the ATF has a rule proposal that says this, then their final rule has to have a reasonable relationship to that. It must be reasonably foreseeable that A turns into B. In other words, proposal turns into outcome. If the logical outgrowth requirement is not satisfied, a court must set aside the agency action found to be, quote, without observance of procedure required by law. That's 5 U.S.C. section 702 sub 2 sub D, by the way, in the federal statutes. In the Fifth Circuit, the logical outgrowth rule requires the notice of proposed rulemaking, I'm going to refer to it as NPRM, to provide, quote, fair notice of the eventual final rule. If interested parties should have anticipated that the change was possible and thus reasonably should have filed their comments on the subject during the notice and comment period, then the rule is deemed to constitute a logical outgrowth of the proposed rule. Okay, everybody follow that? So again, federal government body, whatever it is, the fourth estate, you have this basically notice of proposed rulemaking, this NPRM. Here's the rule we're going to do. It can basically wander, the seams can wander a bit between the proposal and the final rule, but it has to have a logical outgrowth. Otherwise, basically, if it's legislative, then the public lacked notice and input. See how that works? That's the reason why it's super important whether or not this is deemed to be interpretive or legislative. An NPRM is not required to specifically identify every precise proposal which the agency may ultimately adopt as a final rule. Instead, the NPRM must adequately frame the subjects for discussion such that the affected party, that's you and me, should have anticipated the agency's final course in light of the initial notice. As plaintiffs, again, what court said, as plaintiffs, our heroes at the FPC persuasively posit the NPRM and the final rule bear little resemblance to one another. The proposed rule centered entirely on Worksheet 4999, which determined by an extensive point system whether a firearm was, quote, a rifle under the NFA. And unsurprisingly, the comments on the proposed rule concentrated on implementing Worksheet 4999. The worksheet was the focal point of the entire proposed rule to the extent that the ATF represented that, quote, the ATF Worksheet 4999 is necessary to enforce the law consistently. That's the ATF's claims. That's not what I'm saying. That's the ATF's claims. It is necessary to enforce the law consistently. That's why they needed the worksheet. 4999 is the whole focal point of that. Nothing in the proposed rule put the public on notice that the worksheet would be replaced with a 6-factor test on almost entirely subjective criteria. Nor was the public, which criticized the subjective nature of the purportedly objective criteria of Worksheet 4999 and its overbreadth, put on notice that not only would the ATF change the criteria, but it also would make the criteria so expansive as to the subject an estimated 99% of stabilizing braces on the market to so-called enhanced regulations, i.e. felonies, unless you are able to jump through hoops. Because again, lots of folks in many states are not able to jump through hoops, as well as to increase the economic effect of the rule by 9 figures, over $100 million. As the district court found, the logical outgrowth test requires that the proposed rule fairly apprises interested persons and the subjects and the issues the agency is considering, but merely informing the public in a generic sense of the broad subjects and the issues the final rule would address is definitely insufficient. Instead, the proposed and final rule must be alike in kind so that the commentators, again, that's you and I and the other 217,000 folks who overwhelmingly slammed Worksheet 4999, could have reasonably anticipated the final rule. Commentators were given the proposed rule, they reacted negatively, and look, 4999 was born, but long live the new rule. Just because the comments were overwhelmingly negative does not mean that you can basically move forward with something totally different and claim that it grew from the mustard seed of the original proposals simply because we are talking about the same topic. Instead, an, quote, agency notice must describe the range of alternatives being considered with reasonable specificity, end quote. This is not reasonably foreseeable that you basically jettison 4999 and come up with an entirely unrelated 6-factor test, which, by the way, the ATF themselves are claiming are not determinative. What are we supposed to do about that? What are we supposed to do with that? Under the final rule, this is the court, it is nigh impossible for a regular citizen to determine what constitutes a braced pistol. And outside of the 60 contemporaneous adjudications that the ATF released, whether a specified braced pistol requires NFA registration. Various AR pistols without a recognizable brace may fall into the strictures of the final rule. Such an owner may not be on notice that his firearm is subject to criminal penalties without registration. And I will just note here that I've run into any number of folks in the last number of weeks who have reached out to my office saying, hey, I got this pistol brace. Someone told me I might be in trouble. Am I supposed to do something about that? And they just heard about it for the first time ever post the May 31st drop dead date for ATF enforcement and compliance. ATF, you're going to send perfectly law-abiding people to prison on this ridiculous fiasco of a rule. Apparently, the Fifth Circuit Court may somewhat agree. So they ruled, and this is going to be technical, and we're almost done. Here's their ruling. For the foregoing reasons, we reverse the order denying a preliminary injunction and remand with instruction to consider the motion expeditiously. To ensure relative stability, we maintain the preliminary injunction pending appeal that the motions panel issued on May 23rd, 2023, as clarified by this merits panel on May 26th, 2023. This court's injunction will require 60 days, will expire 60 days, 60 with a 6, 60 days from the date of this decision on August 1st, or once the district court rules on a preliminary injunction, whichever occurs first. We direct the district court to rule within 60 days. What does that actual ruling mean in English? The injunction remains in effect for up to 60 days. Up to. The case has been sent back from the Fifth Circuit Court of Appeals to the federal trial court. That's the federal district court. Now remember, there are fundamentally, as far as we're concerned here, 3 levels of courts that we're dealing with. The trial court, we call that the district court when we're talking about federal system. We then are appealing trial court decisions from the district court up to different circuit courts. Here we're in the Fifth Circuit Court, which, by the way, is a record of being pro-firearms, probably the most pro-firearms district or circuit court we have out there. Then, should push comes to shove, and push will come to shove, when this goes beyond the Fifth Circuit, it will be going up to the U.S. Supreme Court. So we have the federal trial court, the district court, the Fifth Circuit Court of Appeals, then the U.S. Supreme Court. So that's basically what the path ahead looks like. So what does this mean? Well, it means that it's going back from the Fifth Circuit back down to the trial court for the trial court to basically re-rule and re-examine some of these issues and to possibly conduct additional fact-finding to see what might be appropriate. So we're basically back to the trial court. And if that sounds vague and nebulous, then yeah, you're paying attention. You're understanding what I'm saying, because that is vague and nebulous. As the judge who dissented on this opinion, and if you go to the link and scroll all the way down towards the bottom, I think it may be on the last page, I don't recall offhand, they noted that basically, look, the trial court, they could expand the injunction so that it's explicitly nationwide and you don't have to be a member of FPC. It could be for anyone or a customer of Maximum Defense. You could narrow it. You could tailor it in a different way. In other words, you can go sideways instead of straight up or straight down somehow. Or you could drop it, non-issue 1 altogether. Those are basically your options ahead. Here are the bottom line takeaways. Now that I've kind of given you, here's what the synopsis is. And I'm going to be giving you also from our community tab section, the quote of the day last. The Fifth Circuit has signaled that they think the good guys, that's FPC, will win, or at least they're winning. Please support the FPC. That's number 1. Number 2, the case is back to the federal district court where a lot of things can still happen. Just because we're winning doesn't mean it's over. This is far from being over, and you are far from being safe. This is not fear-mongering. Look up your local laws on short barrel rifles. This is far from fear-mongering. You are far from being safe from this yet. Number 3, all the other lawsuits out there that are seemingly stalled and watching the fight will probably continue to be stalled to watch the fight. We'll see if one of the other trial court judges decides to surge ahead. My guess is they won't. Time will tell. But for the time being, the fight is here. The fight is with the FPC. The Fifth Circuit did not even discuss the Second Amendment in any substantial way. This went all APA all day. Does this mean that the ATF corrects the APA violations? Let's say they withdraw the rule, they issue a new notice of proposed rulemaking, basically in conformity with what we have here. Maybe they tweak it slightly, but you get my point where I'm going with this. Do they fix this? They reissue it, and now our ship is sunk? Let me know in the comments section below if you want me to get into that, if you want me to explore that particular topic and in another video. I don't have time to do it in this one, but I'd be curious if you find that interesting. Let me know in the comments section of the actual video once this thing's done going live. And guys, before I get to your quote of the day, I just want to thank you for sticking around this long. Both myself as well as the YouTube algorithm thanks you. Derek, who graciously is off camera and volunteered to come in to help me film this for all of you after hours, thanks you. And please let us know that you appreciate this kind of content. Let us know that you appreciate coming in after hours. Click like. It tells both us that you like this kind of stuff. And frankly, the juice is worth the squeeze from our end because you're getting something out of this. And also tells the algorithm, hey, this was an interesting, worthwhile, and valuable video. Other people we think should see it. So thank you very much again. Now for the quote of the day. This one comes from Lao Tzu. A great man is hard on himself. A small man is hard on others. Thank you very much. I look forward to reading all your comments soon. I look forward to seeing you all in the comment field after this video goes live. Keep in mind, I can't see your screen right now. I don't know if we have one person on this thing. I don't know how many people are live or following us along. I look forward to going through and looking at all the live chats. If you haven't commented already after this video goes live, be sure to kick over some comments as well. Show Derek some love. Let my wife know, hey, thanks for stealing us internet. I'm probably going to get some crap from this. Actually, she said, go get him. If you want me to be honest, that's what she said. She said, go get him. When I told her I got to make a video. So look forward to seeing you all in the comment section of the video. Thank you very much. As always, we will see you in the next one. Thanks. Take care.